case briefs, and so much more. LSData's got what you're looking for.
The South Carolina Court of Appeals was called to hear a 2005 case that hinged on the extent of liability assumed in a waiver contract. Christine McCune, who had suffered an injury in a game of paintball, sued the Myrtle Beach indoor shooting range for negligence and strict liability. The heart of the controversy was a loose and ill-fitting protective mask provided by the shooting range. Despite efforts, an employee failed to rectify the deficiency, which resulted in McCune being injured during the game. The shooting range, however, argued that a previously signed waiver by McCune released them from responsibility for any such injuries, except in cases of gross negligence. McCune countered that the unsafe equipment was an unpredicted condition that she hadn't willingly assumed risk for. The issue trickled down to a trial court, which granted summary judgment to the shooting range, implying their signed waiver shielded them from liability charges. Unsatisfied with this decision, McCune decided to appeal the ruling. The appeal was eventually reviewed by the South Carolina Court of Appeals before Justice Beatty. The court, after grueling consideration of the waiver's language and McCune's claim, decided to affirm the trial court's decision. Justice Beatty, upholding McCune's signed release, mentioned that it didn't waive her right to recover for gross negligence. Consistent with the trial court's judgment, McCune was not awarded recovery from the operators or owners of the paintball facility for injuries sustained from the game.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.